Welcome back to the show, my friends. Thomas J. Nelson, your host here with Postcards from Success. I'm pleased to have Ward Heinrichs, Esquire, here. He is from the Employment Law Offices of Ward Heinrichs, attorney at law, here in San Diego. I'm going to be talking to Ward not only about his entrepreneurship, but about the services he provides. Those of you that have employees or are an employee are going to want to pay close attention to this, as he is an employment lawyer who serves both sides of the fence. Ward, welcome to the show.
Well, thank you, Thomas. It's my pleasure to be here.
Yeah, so I wanted to ask you, before we dive into what you do, how did you get on the path to being a lawyer? What's your background? How did you end up owning a law office?
Well, yeah. Okay. So I got on the path of being an attorney when I was in the Marine Corps. I had served as an artillery officer for about 3 years, and then I decided, hey, I'm just not going to make this a career. I started thinking about other things. And one of the things that I've always been interested in when I was going through undergraduate school was law. So I started taking some tests and figuring it out, and finally decided to take the LSAT. And I did pretty well in the LSAT, and so then I said, hey, I'm just going to do this, make it happen. And I went, I was living in Hawaii at the time. I was stationed in Hawaii at Kaneohe Bay. And I came to University of San Diego to do my law school.
Okay, so and then after you graduated law school, did you immediately open your own office, or did you work for another firm for a while?
Yeah, I actually worked for another firm, a couple small firms. One did exclusively criminal law.
Okay.
I worked there for a year and a half or so, and then there was another opportunity with another smaller firm, like 3 guys in it, and they liked to do some criminal law and then some personal injury law. So I started doing that for the first 3 or 4 years of my career.
And then at what point did you decide it was time to branch out and open your own office?
Well, I met a third mentor at that time who, again, was a criminal attorney. And he said, hey, why don't we make a partnership? And I thought, oh, yeah, that sounds interesting. And then we talked about how we'd get business and other things. And I decided, yeah, I'm just going to do this. So that was like 3 or 4 years in. And so then I got a lot of experience in the courtroom, et cetera. Did that for 6, 7, 8 years, I guess. And then decided to go into employment law with another partner. So I switched working for people in partnerships over the years.
Okay, so it's been a bit of a journey to get to where you are today.
Yes, it has. You know, life just gives you unexpected things and opportunities, and you know, you have to jump on them sometimes. You know, one that comes to mind really quickly, if I may,
Please.
is I was back in the days of like 2003, 2004. Had started building an employment practice with my partner at that time, and she had always done employer stuff. And I looked in the yellow pages, because the yellow pages was big back then. The attorneys advertised the yellow pages, and saw, hey, there's only one person advertising for employee work. And I said, you know what? I think we can take advantage of that. So we got like a 3/4 page ad geared toward employees. And then we got this big class action and settled it some years later, and it worked out very well. So that, you know, sometimes an opportunity just pops up and you just got to jump on it.
Well, and you know, I would think a lot of people just assume lawyers, you know, they make the big bucks. You're the big attorney, but you're running a business like any one of us are. And at the end of the day, you have the same challenges, or maybe different challenges, that are unique to a law firm. What are some of the things that you deal with as a business owner and a lawyer? I'm always curious to know the challenges that people overcome as they're running their business.
Well, my business has changed over time, especially the last 10 years. I did mostly employee work 10, 12 years ago. And over time, I started bringing on more employer work, and I'd get some employer work from my partner, who that's pretty much all she did. We kind of crossed over a little bit. So the challenge has always been, well, because the market is moving so fast in the legal area. it's really not a stationary thing, and there are many attorneys in California and especially San Diego. So you really have to monitor the market. You can't just be in a small town, one of two lawyers and do everything. You got to specialize and get good at what you do, and try to look at the market and say, boy, I need to maybe emphasize this a little more rather than that. And so it's always been an adjustment to the market over time that I've found. Like now, in the last 5-6 years, I've really focused on employer work. So I've been pushing that side of my practice much more than I used to 10 years ago.
Okay. So, I mean, and the advice you just gave would be advice that I've gotten from my business coach, and I know a lot of other people that own businesses have received from their mentors. I mean, so you do deal with the same challenges. You have competition. You compete for market share. Marketing and branding your business with a focus is important. So, I mean, it's like any other small business. You have similar challenges that we all have, and it sounds like, yeah, and the way you handle it sounds like the same way when I'm with my coach, that she's pushing on me. The more you specialize, the more people can focus on what you do.
Yes, and I think especially in a crowded market, San Diego is one for realtors and attorneys.
Correct.
You have to do that.
Okay, so let's talk about because I mean I've known you a while, and I know you to take cases for both employees and employers. You're more focused on employers right now.
Yeah, I'm emphasizing that in marketing. I'm definitely emphasizing that.
Okay.
But I do take cases from both sides.
Okay. Well, we'll talk about both sides, and I guess my first question would be, I'll make a statement then a question. It seems like there's an advantage to working with you because you've both worked for employees and employers, so you have a little inside track on what the other's thinking when you're representing the opposite side of the fence. But on the flip side, the question is, do you ever run into challenges of people being concerned about the fact that you can represent both an employer and an employee?
I've never had anyone face me with that question directly.
Okay.
I'm not sure if people think about it in the back of their minds. I always say it's a strength for just the reasons that you would mention.
Yeah, I would agree. Okay, so let's talk about it. So how do employers get themselves in trouble where they need a lawyer?
California is highly regulated in many areas, and I would say especially probably in employment law. You as a business person know, and many other business people out there know, you have to deal with so many different regulatory agencies and regulations from those agencies. The EDD is a big one. They'll come in and audit you and look to see if you've been doing the right things with your employees in terms of withholdings and other.
Who's the EDD for those that don't know?
Employment Development Department.
Okay, so they kind of police employers?
Yeah, they police several areas. Probably the most common one is unemployment. They screen unemployment cases to see if they qualify. They notify the other side, the employer, and then they set up hearings if the initial findings are challenged.
So some of the common things I would guess that employers face, maybe when they're on the wrong side of the law, is maybe discrimination or unpaid hours that require employees to work overtime off the clock, things like that. Am I on track with that?
You are. I'd say those are probably the two biggest areas I see.
Oh, okay.
This really is what we call wage and hour, and that's the unpaid overtime, the unpaid minimum wage. I'm doing a couple cases. I have both those issues right now. Misclassifying employees as independent contractors.
Oh,
that's a big one.
Yeah.
Misclassifying employees as exempt versus non-exempt, and exempt can be, if you're qualified, can be paid a salary, but if they're misclassified, then they might be getting all this extra overtime that they haven't gotten because you gave them a salary.
Oh, okay.
Meal periods, rest periods, those are probably the biggest things I see. And then discrimination's a pretty close second. People feel harassed. And you really see that with employees more than employers, people complaining about being harassed.
Okay.
And if an employer get sued or there's some type of claim made out there, that's when they start getting really concerned.
Well, I'm going to jump back because you brought something up that is huge in the real estate industry, and that's the misclassification, whether you're a W-2 or a 1099, independent or an employee, essentially. So, and honestly, that happened to me. I mistakenly thought I had an assistant that was an independent contractor until a lawyer I was representing to buy a home caught wind of my setup and said, no, 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 you've got an employee, and I panicked. So immediately had to sever that and go to virtual assistants, where that takes the burden of that off me. But let's talk about that. So how do you know if you truly have an independent contractor versus a W-2 employee?
Wow, that's a big question, and it's changed just recently.
Oh, it has? Okay.
Yeah, the Supreme Court passed, or didn't pass, made a holding in a new case called Dynamics. And there they said that under the, I'm going to get a little technical here on it, under the wage orders, which govern some wage issues, not all of them, the labor code's got more, they said the definition of employee there is broad enough that we need to change the test to meet how broad this really is. And this, you know, the wage order has been there for years, and the Supreme Court has now said we're going to tackle this. And I think the reason why they said they're going to tackle it is mostly because of the gig economy, like Google and stuff and other things. And so they said there's too many people out there that we think are probably really employees under the wage orders. We're changing the test. It's called the ABC test. And the main part, the one that probably trips up most potential employers would be the middle, the B part, the B prong of that test. And that is whether they work in the usual course of the business. And when you talk about an assistant, that's probably in the usual course.
Yeah.
The old test used to be, well, how much control did you have? You know, just in a nutshell. I mean, it was more complicated than that.
Sure.
That test is still alive, and it's probably the A prong of the new test. But the B prong has widened it dramatically.
So now these changes then, are they more a positive or a negative for employers? Is it made it more difficult, or has it made it easier to have an independent contractor?
Oh, it's made it harder. There's been
okay. I just want to make sure I'm clear on that.
Yeah, a good question. It will force more it will qualify more employees or workers as employees versus independent contractors. No doubt.
All right. So if I'm telling someone where they need to report to work and at what time and what the work they're going to be doing, I'm pretty much dictating work orders to an employee.
And that would meet, all right, so under the ABC test, if the employer fails any one of those, then the person is an employee. So what you just talked about was the A prong of that test.
Okay.
Fail that one. But if you passed it, you still have to pass B and C. I mean, if you failed A, you still have to pass B and C as well. Okay. And it's really the B one, whether you work in the usual course, because that's, there's a case out of New York, and they run the same type of test, and they said there that a band that played, once or twice a week at a bar is an employee.
Really?
Yeah. It got that broad, and they run a very similar test. Now, whether California was that broad with it, I don't know.
Wow.
The reason was it was part of their marketing efforts, and they had bands play there regularly. So it was in the usual course. Now, I honestly, I don't love that ruling, but that's how broad this test can end up being.
Wow. So this makes it extremely difficult if they follow to the letter.
If they go that broad. And the Supreme Court did mention that in their Dynamics test, or Dynamics case. They said, hey, if we just read the direct verbiage out of the wage order, anyone could be an employee.
Right.
We're going to put some limits on it, but we don't know what they are yet.
Oh, nice. So, but see, the part that confused me when I thought I had an independent contractor is I basically said, this is what needs to get done this week, and I'm willing to pay you X amount of hours a week. You can come in whenever you want, but this is the work that needs to be done by Friday. And I didn't dictate dress code, and I also allowed her to work from home if she so chose. I thought that was loose enough, but apparently it wasn't. So how do you actually, it makes it confusing to me as someone that if I was to hire an independent contractor, I'm obviously dictating a specific job that they need to do. They're giving me a time frame they can get it done in and a price. I'm not telling them how to do the work because they're the professional. Is that basically an independent contractor?
Yeah, you brought up some good issues because you're saying, well, I was very flexible. I let her do work whenever she wanted to, et cetera, et cetera. But the problem you're running into in that situation is she's carrying out tasks that are part of your business.
Okay.
Essential parts of your business. And that test is broadened under the usual course standard now. It's even tougher to meet now.
Okay.
But a professional, if they hold themselves out as a professional and they have many clients, then that type of person is going to be an independent contractor. I mean, obviously there could be some exceptions. Certainly there's in-house counsel that are employees. I'm thinking of attorneys right now. But if they work for more than one person, you're in pretty good shape. But again, I got to caution you, the usual course prong of that new 3-prong test, ABC, could even qualify someone who holds himself out, because if you meet that test, the C part, you could still fail to be a part. It's possible.
And the only way to have an independent contractor is to pass A, B, and C?
Yes.
Okay, got it. So if you fail any one part of it, you have an employee?
Yes.
Okay. Now, and I don't want to belabor this. We got other things to talk about, but it's such a big issue in real estate, and I know I have a lot of realtors that listen. So what about rental property, for example? Let's say you have 10 rental properties, and you use the same gardener for all 10 rental properties. Does that make him an employee, even though he owns his own business, but he does regular work to all your properties, or a handyman or anything like that? Are you venturing into employee status at that point?
Before dynamics, I would say you're probably okay, and I have to look at the specifics. It's a fact-driven test. There's many factors in it, especially the old test. Now it's a little, but you're going to run into the problem of, well, isn't that work in the usual course? And they're doing 10 of your properties. I mean, I think maybe one. Again, the Supreme Court could say everyone's an employee. The language is broad enough. They're not going to do it.
Right.
We just don't really know where that line is yet. And I would say with one property, maybe you're okay. With 10, you're getting less okay. And I don't have an absolute answer because it just hasn't been tested enough.
Okay, we're too soon into the change to know. There's no precedent yet.
Very little.
Okay. All right, fair enough. I just, these are both personal and interview questions for me because I'm in the industry where I went through this. So and I know so many people that are fooling themselves in my industry thinking they have an independent contractor doing 1099 wages, and they don't.
They don't.
And they're one lawsuit away from finding out.
Right. And that's often how you find out. Usually if the work environment is conducive and everyone's happy, not a big deal. It's when something happens. Then they go, how can I get my ex-employer or my ex person?
Kind of like a divorce, and it can get vindictive.
Right.
All right, so let's switch gears. I know that with the employer representation being your focus, what are you doing to drive that business in outside of the marketing you do? I mean, how are you best serving employers and getting the word out that and letting them know what you can do for them? I mean, they might not even understand all the facets of the services you provide. So share a little bit about that.
Well, one thing I do is I do informational podcasts like the one we're doing. Now, I haven't done a video, and we talked about this. I haven't done a video yet like this, but I do regular podcasts with what I would call, it's an online magazine. It's called Big Blend Magazine.
Okay.
And once a month normally, or at least 10 times a year, I'll do an article and then talk about the article on the podcast.
Okay.
I mean, mostly it's employer driven. There are certainly employee issues in it. In fact, most of the issues that you would raise in that context would benefit both the employer and the employee to know about. Online, I have a website. Websites, I generally pick up more employee work than employers. I've changed it a little bit. I'm probably going to make some more changes so that there's a clearer distinction between what I can do for employers and employees. Haven't gotten there yet. We're getting there.
Yeah.
Then social media is big.
Yeah.
LinkedIn is helpful pretty much. I know I've gotten work directly from LinkedIn.
Okay.
You know,
is the challenge too that, I mean, do you find that most people only contact you when they need you or almost when it's too late versus preventatively?
yes. Most of my calls, whether it's an employee or an employer, are, I've got a problem with an employee, and I'm thinking about employers right now. I got a problem with an employee. How can you help me? So that's most of the calls. And I get it. The other thing I do for employers is I talk about risk, like we just did with the ABC test and independent contractor. You can't eliminate that risk. I'm sorry. You can't eliminate it. Now, maybe there's going to be some black letter law eventually where I can say, well, that situation sounds pretty eliminated. But what I can talk about more intelligently is saying, well, if you do X, Y, and Z, the chances of you getting sued and the chances of you losing if you do get sued are going to go down.
Okay.
So I talk about, again, controlling risk for employers mostly.
So you're minimizing it, but you're not eliminating it because that's not realistic.
It's really not in most cases. Yeah. So, but employers do call me with their problem, and I try to help them solve it. And I try to come up with creative ways. I do understand what the employee's attorney is doing. And then normally I get a relationship from that where I go, well, hey, have you thought about these things? And that would help you control that risk. So that's usually where I can start talking about risk.
What's one of the worst things you've seen an employer try to get away with?
Oh my gosh. All right, I got to be a little careful.
Yeah, I understand. No names.
Yeah, definitely no names. I've seen situations where there's a looser type of work environment, and I'm really thinking of like restaurants, and where the owner and the manager are really big picture dudes, and they think about how to get business in and, making sure all the food comes in right and getting the cheapest prices, all this stuff. But then they let some other people, run the employees. And I've seen situations where people aren't clocking out, and I'm sure their shift is much smaller.
Yeah.
And so then you've got this huge clock time, and then there's an issue. Well, do we pay it? La-di-da-di-da. And if it goes on and no one really is paying much attention, then over the years, that can end up being a pretty big case.
Oh, yeah, because they've established a pattern. So then how do you prove?
Well, if you've got a time clock that shows them working 14 hours,
yeah,
how are you going to disprove that? And they really might have just not clocked out, left for 5 hours, come back, worked a little more, and if it's that loose, you got a problem.
Oh, wow.
Yeah.
Wow.
So I have seen things like that.
Right. So it's funny because the way you talk about the what you see from employers is kind of the same sloppiness I see from a lot of landlords, the way they run their businesses, because they don't realize they're running a business. They're not just renting a home. And they get really loose with paperwork and rules and enforcement. And then it comes back to bite them because they've established a pattern of being a slacker. And then, but the tenant knows their P's and Q's and take the landlord to the cleaners. So it sounds like it happens in business a lot too. Hence, you have a job.
Yeah, keep me employed.
Yeah.
There are people who like to run a looser model than many people.
Yeah.
Business owners. And by and large, what I've seen is it works because people like them. They feel very comfortable in the employment area. They feel like they're actually being treated well. But what happens is when there's one person who's discontent, maybe they come in discontent. Maybe they eventually get discontent.
Yeah.
That's when the problems arise.
Yeah. They take advantage of the lackluster. Well, the question I have I'm going to switch gears and go to the employee side. I know that's not as much of your focus anymore, but still curious about what are the typical complaints you get from employees about their employers? Because I think it would help the employers listening to hear what employees typically complain about to get ahead of those things.
Yeah, and to be clear, I do talk to employees all the time too. So
okay,
I wouldn't want to exclude them, but typically, it's the most common thing probably is discontent. I feel like I'm being harassed, and harassed has a very specific definition under the law. You have to be harassed because you're a protected class. So if you're just being bullied because they don't like you, then that's probably okay. But if they're harassing you because you're a woman or harassing you because of your color, that if you can tie it to a reason that's protected, that is what creates true harassment that you can actually do something about or file a case about.
Okay.
But what I hear is, and often say is, well, I get it, you're not being treated well, it's really not right, but it doesn't sound to me like it's the type of harassment that is protected. So I hear that a lot. And then wage and hour stuff, I'm not getting paid my overtime. I'm getting paid minimum wage sometimes, not that very often. But minimum wage has gone up so much, and it's going to continue to go up. I think we'll see more of that kind of thing. Meal periods, I hear those types of things a lot.
Okay. So with the employees, though, like for example, when let's just say you've got an employee that is trying to take advantage of the situation, like maybe they're a bad employee. But they know they're going to get fired. And I'm bringing up something specific that I know a business owner went through that owns a restaurant. And she got wind that she was going to get fired. And so she filed a sexual harassment lawsuit to kind of trump getting fired. Is that, do you deal with that kind of stuff like retaliation? I guess it would be what it would be called.
Yes. That I've seen that move used, many times over the years. And what happens is if they file that harassment suit, now if they are terminated because they filed that suit, that's called retaliation. And because it's filed so closely to the time when they know they're going to get terminated anyway, you've got a time problem because it's so close in proximity. So that can really create a problem. It doesn't mean that you can't fire them. You can say, hey, look, I'm firing you because you're lousy and I got all this paperwork that says you are. You probably have a pretty good case, but you have more risk than if they hadn't filed the sexual claim.
Okay, so you just said something really important, because it sounds like employers should be keeping good records of their employees' behavior, if you will, or lack of professionalism, or whatever the complaint is. So if they keep like a log of some sort documenting these things, is that helpful, or is that just hearsay?
No, it's helpful.
Okay.
Yeah, no, you want to keep good records, and that's one reason why I brought that up. If you don't have the good records, then now you got to really think, what if I terminate this person, what are they going to do? I don't have records that support all the bad things they've done. Doesn't mean, that you still couldn't come in and testify to some stuff, but it's so much more powerful if you actually put a writing in the employee's file and counsel them. Way better than just, shooting from the hip, even though it's true, without any backup documentation.
Okay. Other question I have is that, when you talk about protected classes earlier about the discrimination, does that include age?
Yes, it does.
And physical ability?
Well, disability, if there's a disability, then yes, that's a protected category. So
could somebody that say, like, and I'm at the risk of being discriminatory, I'm going to ask you a scenario.
I advise you not to.
well, let's just say like an 80-year-old man or a guy in a wheelchair goes to a construction site and says, hey, I want to help you build houses. I mean, realistically, they can't be hired potentially to do, climbing up ladders and lugging heavy stuff, potentially based on their age and physical condition. I mean, I guess what I'm trying to ask is, like, when you have a situation like that, do you have a legitimate way of saying I'm not hiring you, or are you setting yourself up for a discrimination suit?
Well, under the situation that you just described, if the person can't fulfill the essential functions of the job with or without an accommodation, and this is disability discrimination analysis.
Okay.
So it's, can you perform the essential function of the job with or without an accommodation? And the case you just spun out doesn't sound like they could.
Okay. Now, what would be a reasonable accommodation?
Well, that's depends on the situation.
Okay, so it's all situational. So
it really, what's a reasonable accommodation for Coca-Cola can be very different than for the mom and pop pizza store.
Gotcha. So so that's all considered then when that's being evaluated.
Yes.
So in other words, if I'm not going to hire a guy in a wheelchair because there's stairs to my establishment and I'm grandfathered in, but I could put a ramp in and hire him, that I might have a problem not hiring him, versus a construction site where there's just no way this guy's going to climb ladders and lug lumber and go up to the second story and put in a roof or whatever. I mean, would that be kind of a good?
I think that's pretty good, actually. If you can accommodate this person with just a ramp, maybe that's reasonable. Again, it would depend on the situation. There's all sorts of access laws too that I'm not going to get into.
Right. I realize I'm probably broaching that, but
yeah.
I mean, does cost come into it? Like, because what's determined to be reasonable? Like, I mean, what if that ramp costs me $3,000 and I don't have $3,000 to put in a ramp, and this guy's a minimum wage employee? I'm never going to recoup that $3,000 anytime soon.
Yeah, if it puts an undue burden, I'm using all these buzzwords that are used in the analysis, undue burden on the business, then it wouldn't be reasonable.
Okay. Yeah, it's just, I mean, because it seems like these days there's a lot of people looking for the easy way out, both in, employees and tenants. I see it in real estate a lot where, hey, why get a job when I can sue this guy? And there's those professional people, like people out there seeking out the situations that allow them to sue. I mean, someone like that, because I know there was somebody like that in real estate and specifically in a wheelchair. I heard about, trying to bust businesses that didn't have proper handicap access, and, deliberately going around. I mean, when you run into somebody that does stuff like that, I mean, do they have the right to do that, or eventually do they get shut down because what they're doing is, it's, I don't know if vindictive's the right word, but I mean, it just seems like they're making a professional victim out of themselves.
Yeah, well, there's a tension in the law there. If someone files frivolous lawsuits, they can be required in the future to prove at least a minimum level of support for the case they filed. But that takes a period of time before they can get there. Mm. The court then highlights them, and then they really have to bring the case before a judge. The judge says, yeah, you can file it or not. Normally, that's not the case. You can just file, and then you duke it out in court. So that's definitely possible. You did mention someone who, there's different newspaper accounts about different people who've done this over the last, couple decades.
Yeah.
There was one recently, I think he was an attorney who was prevented from filing cases in Arizona and now has filed some cases in San Diego for access, talking about disability access.
Right.
And I'm not sure where those are going. I think it's pretty recent. So you can get pretty shut down in one place and maybe open up the same thing in the next place. In some cases, if there's really no access, that's probably if you keep hitting companies that just haven't got the right access and it's required in the law, I don't think you'd ever be what they call a vexatious litigant.
Okay.
Those are meritorious claims.
All right.
I don't really do the access stuff too much. I've done a little bit. So I'm certainly not an expert in that area, but I know enough about it to know that certainly there are people who have filed lots of cases and have been able to settle them. There was, I can really go on and on about this. Maybe I should stop. There was the defense would remove them in federal court, and they get better deal in federal court because the law is a little different. Maybe the judges look at it a little differently. There's all sorts of ins and outs about this type of litigation.
All right. Well, I mean, it's just, you hear those stories. So I've always been curious to know from a lawyer's standpoint, how that eventually comes to an end. So it sounds like they can, in some cases, run the course, and then they lose their credibility at some point.
It's possible to be a vexatious litigant.
Vexatious. Okay. So with your expertise, and I'm going to ask you a broad question, but you can choose a more specific answer. How would you advise employers to keep themselves out of trouble? I mean, what's a reasonable set of guidelines for employers to, get ahead of these kind of employee complaints and things that bring them to court?
You need, probably in most cases, unless you have the right background, you're going to need some good advice. I mean, the web of regulation is so tangled that it's probably, once you get to a certain point, you have the money to do it. Because not everyone does, and when you start, usually it's on a shoestring, you just got to do your best. You get that. But when you get to a certain point, it's good to have someone come in who has expertise and look at the business and say, hey, I think you could do things differently here to protect yourself. I think you can reduce your risk over here. So that would be ideal, an ideal way to handle it.
So maybe do a consultation with an attorney like yourself. And that might be something that they do the same way you meet with your insurance agent once a year. You might want to meet with an attorney once a year to just keep up on what's current, what's changed. I mean, and yeah, of course, some businesses don't have that luxury up front, but I mean, at what point would you say it's kind of mandatory, like at a certain level of income or a certain amount of employees? I mean, when would you say, hey, look, at some point you got a budget for this?
I think when you get 10 or more employees, you really need to start thinking about a handbook.
Mm-hmm.
I would even say at 5, because now California law has changed.
Mm.
There's a lot more burden on employers who have 5 or more employees than there used to be.
Okay.
There's medical leave issues now that they didn't used to face. There's things that are going on. So I used to say 10 all the time, 10 to 20, and now I'm just thinking the law's changed just enough recently. Maybe if you have 5, you really ought to start thinking about getting that handbook in. Have an attorney look at it, though, because you can just get one off the internet, and there's too many problems with that. It's worth paying an attorney, some money. It's not going to be too expensive. So take a look at the handbook and modify it for the business. Okay.
And the handbook you're referring to, what is that?
That's an employee handbook. It's really, I call it the roadmap to how you're going to work with your employees. You have to let them know that they have certain rights, and then it also has other issues. It covers other issues.
Okay. So I know we got to wrap things up here in a minute, but I mean, is there a question I haven't asked you that I should have, that you want to make sure people are aware of?
Wow. Honestly, I think you've done a great job, but you've hit all the things that have been top of my mind for a while.
Okay.
And so I think we got out most of the essential stuff.
All right, wonderful. Well, Ward, if people want to get in touch with you, and well, I guess one last question is, can they consult with you, and do you charge for the first consultation, or is it for the second one on? How do you structure your consultations?
Yeah, no, well, part of it depends. If they call me up and say, hey, I really want you to do X, then I'll probably say, well, I need to charge you this for X. But if they're in the exploratory phase and they're saying, I just want to meet you for lunch, or I want to, I think I might have a problem, that's certainly I do for free. You'll spend 20, 30 minutes just talking about it and seeing what's going on, and then we can go from there.
Okay, fair enough. So if people want to get in touch with you, what's the best way to do that?
They can call me at my number, my business number, 858-292-0792. I'm also on the internet at bestemploymentattorneysandiego.com. Those are probably the two best ways to do it. Well, email's fine. Actually, I'm going to change my email, so maybe just internet or the phone.
Yeah, website or your phone number for now. And we'll have all your contact information on the show notes too. So I want to thank you so much for coming on the show and helping us out with answering some of those questions that I'm sure some people had in the back of their mind, and they're maybe in a little denial, and now they got some truth. I know I was when I was employing my subcontractor and then found out I had a W-2 employee. So yeah, I mean, you know, because there's no one that teaches us this. You know, so I think you make a great point about at a certain point, which in California sounds like it's 5 or more employees, you may want to sit down for an hour with an attorney like yourself and just go over how your business is structured and how you're running it and the employees and the potential growth, and get ahead of the problems and try to minimize the risk.
Yeah, it makes a lot of sense, because you don't want that lawsuit hitting you, and then all of a sudden you're going, oh, that's $30,000 I want.
Yeah, absolutely. All right, Ward, well, I appreciate you being on the show today, and thank you very much for your time and all your great information. And folks, we'll look forward to seeing you on the next Postcards from Success. Until then, have a great and wonderful rest of your week. Bye-bye.